Okay, hello everybody. Still getting myself sorted out here. So, uno momento, por favor. I hope everybody's been having an okay day today. Great days, I'm not sure, but definitely an okay day. Oh, I know, today was crazy. It was just crazy town. I don't know how else to put it. It's ridiculous, in my humble opinion. I don't know. Maybe this. All right. I'm sorry. I'm getting my rings on. It takes me a minute because I'm a ring diva. So there's that. All right. Here we go. We're getting there. Oh no. All right. Wardrobe malfunction. 1 minute. Hello, Bruce Wayne's mother. You haven't read any news. That's probably a good call. The news is kind of jacked up right now, in my opinion. So I'm kind of waiting for things to get sorted out in the courts because the stories going around don't quite match how the law is working. So I'm like, all right, we'll wait. Hello, Bubbles. Hello, welcome. So, hello, Sky. Yes, I've got a little wardrobe malfunction here. So, too overwhelmed by the news. Understandable. I mean, the news is just like... sorry, I had to get my thing glued. It's scary. The news is really scary right now because I think you're only getting little bits and pieces of what's going on with the Venezuela situation. Quite frankly, that's very distressing. In my humble opinion. Right, the stories don't quite match how exactly right. So it's a little troublesome right now. So I'm kind of pulling back a little bit. Hi, Gretchen. Never worry here. I definitely will be making sure to follow this case, the Venezuela case, without a doubt. But I also know that at this time tonight, the info that's coming out is not, it's not quite right. So there are some things that are missing. So I'm going to kind of wait until I get better info. And again, even by going through the court. So, oh no, sleepless. Oh my gosh. Yes, here I am. I'm here. Such that I am. I'm putting my hair up with a pen here because I don't have any other things to do. Does all this going on stress me? It does. It does. It stresses me out a lot because I love this country and. We screw up a lot here in the U.S. We make a lot of mistakes. We all do. And even our bonus case tonight's about some mistakes we've made in the past. But, we clean it up. We go in and we fix it. And for me, the most stressful thing is the list of everything that we're going to need to fix. Like, not necessarily put back to how it was before, but just fix so that it complies with the law. So that's what bothers me. That's what I'm a little bit worried about. A shamokin? Are you a TikTok attorney? Oh, that's great. We are a nation of laws, not men. True story. Don't watch the news, can't handle it. I understand. Same. Need you to keep us calm. Oh, you bet. We're gonna make it through here. It's just, I'm not going to be sharing my tang with my neighbor anymore. All right? I said what I said. I said it. Too damaged for a parent. No, I don't. I'm not sure I'd go that far, actually, in my humble opinion, which is one of the most precious things I think about the United States is, we're like, you can kind of do these crappy things, but we're going to try to rein you in. And if you don't want to get reined in, then, bad things can happen. Oh, of course. Hello, just moi. Hello, you're hilarious. Well, I do try. I appreciate you. Oh, that's so sweet. That's so sweet. All right, everybody. So, as I had said at the start of the show, huzzah, it's the show. I am keeping a very close eye on what's happening in Venezuela. All right, now there's some weird stuff going on. I was on live, I think just yesterday, actually. I was on a live and talking about this a little bit, but I really want to make sure that there are certain cases and things going forward that we don't like push to the back burner. So I know a lot of people coming in on the Venezuela situation, and especially here on TikTok, some of the attorneys out here doing amazing work. We love that. So hello, spooky. Maxi girl. That's fun. Anywho, I feel comfortable that this is being reported on by good people. So, especially Legal Dad, everybody. I've got to give a shout out to Legal Dad. He's just, if you don't really know what's going on and you're like, oh my gosh, the world, it's ending, he does some great work over there. So he's also on the tube, so make sure to follow. But because of that, I feel comfortable kind of dodging in and out where I think it's appropriate. This particular piece here was written in December 5th of 2025. And this is out of the Congressional Research Service. We've talked about that before. This is a nonpartisan entity that's like hanging on by their fingernails, I believe, at this point. And they go through the law, and then without caring which side wins or whatever, they set it out. And I think they've done a pretty good job here of giving us an overview when it comes to sanctions and such. So if you're interested in a primary source document, which is what this is, it's just a write-up by, attorneys. You can take a look at this one. This one's December 5th of 2025. Very helpful, I have thought. It is. It's being repeated. Right. We love that. Hello, Kaya. Hello, June Marie. Welcome. Iceland to the floor of her votes. Yeah, he needs to stop doing that crap. That's like, dude, stop. Don't piss off Denmark, all right, everybody? If there's nothing else you take with you, don't be pissing off the Denmark, because they'll come for you. Yeah, it's drier than the Sahara. I know, it's so funny. All right, why are attorneys afraid to file lawsuits against DEA, CDC for harming doctors and the patients? All right, so Joe, great point. And I would encourage you, come on over to my the homepage, I guess, because what you'll see is I've done post after post on all of the lawsuits. There have been so many lawsuits filed by the people being hurt, by the nonprofit organizations that help the people that are being hurt. So there's nothing that's like, well, we don't really want to deal with it. No. We're at I think 550 lawsuits. If we win, we don't know, but the lawsuit filing itself is already showing moving forward. So that's a good thing. Whew. All right. What's the difference between the Library of Congress website and the congress.gov website? That I don't know, because I'm not on the .gov. You bet, Joe. You absolutely bet. Anytime you are like, what's happening? You just, drop me a question. So the Library of Congress, of course, is, okay, I gotta take a deep breath. All right, so the woman that was the secretary, so the librarian, I shouldn't say secretary, that's the wrong word. She'd been doing it forever. She got fired, just like boom, fired. Now, she's part of several people in very important positions who were fired. And so many have filed lawsuits. Others have just said, I just don't want to deal with it anymore. So she's gone. So now it's Todd Blanche, who is like the Library of Congress person. Because what? He's qualified? No, because he's a minion of the Dark Orange Lord. So he's in there now doing it. But, of course, Congress has also resources available, hopefully, which, hopefully they didn't take all of the resources out of the Capitol when they stormed it 5 years ago. but that's different. So this is its own entity. Well, not this one, because this is a Congressional Research Service, but the libraries are in there. Oh yeah. Oh, thanks so much. Thanks so much. Yeah, it's definitely heartbreaking. Heartbreaking. The law books you use, are they online as PDF? So, villain, hopefully, I was like, is that two L's? Everything that I use on all of my lives are going to be online or public resources in some way that are free. There are a couple times where I pulled in a little bit extra when I was working on some cases to explain to everybody, and I needed to go through the PACER process. But all of the filings here, they are all public, available to anyone who requests it. Now, you might say, well, what about the Constitution? And I do have a book of the Constitution, but it's also online, of course. I like the Constitution Center in Philadelphia. I think they do the best work, honestly, of explaining what's no longer working. So I think they do a good work. This is one I got when I visited the little White House in Key West. So another one you might be thinking of is Model Rules of Professional Conduct here. This is 2020, so it's old, but it's still good. Like, there are a few things that I kind of add if they've been put together a little bit better. But these are our ethical rules, and this is through the American Bar Association. You do not have to buy the book. They have all these rules available online. So if there's just a few you want, you can just kind of bookmark them. They're all available. Excuse me. And then I have Black's Law Dictionary. Of course, you don't need that. You can go online. And then probably the biggest ones I use are the procedural rule ones. So we've got criminal procedure here for the feds, and then we've got civil procedure here for our civil cases. These are available, anywhere books are sold pretty much, or, if you're willing to go into the jungle. Wink, wink, not sponsored. So that's no problem either, but these are the ones that set out our actual rules. They are also available online for free. If you go to the website, you can go and hunt around and find what you're looking for. If you don't want to buy a whole book, you are like, I just need a couple of rules, then, you can pull them and do whatever you want with them. All right. So these are my other ones. So those are available as well. The jungle, exactly. Yes, all of these you can go into the jungle and find. This is my favorite. This is, I have been teaching, studying, using the rules of evidence for 20 years. So the rules of evidence, they will put out a new little book every year. Like, this is 2025. There will be a 2026 version. But if none of the rules have changed, I just keep it. Now, the one rule that keeps changing around, which people probably notice, sure, because we're all reading the rules of evidence, right, all the time, is hearsay. So hearsay is a nightmare, a necessary nightmare. But sometimes they'll change the language in here. They'll change the numbering in here. And so if that happens, I'll get a new edition, but I haven't seen any changes in it. So again, in the jungle for those that are interested. So those are the primary sources that I use, all also free online if you are interested in that. My other suggestions would be, again, these are just for studying and learning. I do have a small Black's Law Dictionary here. This is very small. It's a pocket edition. This one's the 6th one, and that's nice to just have around, especially when you're first getting started. And then I do also recommend, depending on how far into constitutional law you want to go, because I'm at the bottom of the rabbit hole, okay? I'm at the bottom. But we do have 2 sets of essays here. The Federalist Papers you've probably heard of are available for free online. Not sponsored. If you're interested in why Constitution was setting out a government for the entire United States, right? So we've got Hamilton, Madison, and John Jay. who was the first Supreme Court justice on the court. And then we have the Anti-Federalist Papers. So then we have the other side saying, states' rights, man. Why are we forgetting about how important our state rights are, which is the big question. Patrick Henry and others. Now, this Patrick Henry fella was an amazing orator. I've studied a lot of his speeches because it was so impactful how he delivered his speeches and the content. So one of the things that I studied in college was rhetoric, and I spent a lot of time reading his speeches because I think they're really good. Now, as a person, I'm not sure about that, but he's a very good writer and orator. So those are just some extra fun ones if you want, for fun. The Federalist Papers. For fun, everybody. So, bottom line here, I am keeping my eye on Venezuela, but I also want to keep going forward on our cases that we've been working on here too. So, with that, let's go ahead and get started. Now, yesterday, I think it was yesterday, it might not have been, and I'm sorry if it wasn't. But yesterday we had a lot of fun because I had put out this challenge that if we can get to 100,000 likes, we're not voting on anything over here, but if we can get to 100,000 likes, I have brought in a bonus case to just take a little bit of a break. We'll go just a few minutes to walk through a really good historical constitutional law case. So if we hit 100,000, just let me know. And I've got the case for tonight, and I'm really excited. It's a really, really good case. All right. So let me know when we hit 100,000. Very excited about it. Hey, Mayo, welcome. Oh, thanks, Glowing. Oh, I appreciate that so much. Right. Auto tapper. That's funny. All right. I need to get one of those. Oh my gosh. That's right. All right, here we go. So this was filed just yesterday, everybody. This is some hinky business going on here. Now, I'm not going to say her full name because, the talk is in a weird place right now, but I will call her Maxie, all right? Now, I think that word gets through okay. We're hearing some weird stuff about this, right? They went, the librarian from the Library of Congress went over and sat down and talked with her while she was in the clink. And then she was moved to a less prison-y atmosphere place while she serves her 20 years for being a part of this horrible situation. Right. So, she's in a new place. And then now everyone's really keeping an eye on her. And she has here just yesterday. Yeah, this should not even be here on the table. But this is what happens when you have people who aren't, good. So this was submitted by Bondi as well as Blanche, the U.S. attorney there, to give some kind of, substance or reliability on it. This letter, again, just filed yesterday, sent to the judge. So I will go ahead and read through this letter, and then what I want to do is take you through her docket, everybody, because this is it. I'm not going to get into the details of the crimes, specific outlines of that. That's just not my style, but I do want to look and see what's going on with this case, because it could very well be possible for her to have some benefits come through because of her relationship with the orange. Right. So, and with that too, I do use orange instead of the name, because I personally have noticed that I have been getting dinged quite a bit. I was using his name for 2 years, and then it seemed like after the election, anytime I mentioned his name, I would get into trouble. So I just call him Orange now so that I don't get into any trouble. Right, but VC. Oh man, wouldn't that be nice though? Anyway, don't get too close to my dreams. Here we go, everyone. Let me get my sticky up here too and ready to go so I don't forget, because I will forget. Even if I write it down, I'll forget. Oh no, where's my preferred sticky? Oh my goodness. Oh, nope, here it is. Nope, here it is. I really have too many sticky notes going on here. Well, yeah, I mean, right? I mean, that's not, you can do that. Why can't we? Yeah, we love oranges. They do have vitamin C in them, right? So we like that because that can prevent scurvy. And we all need to be more careful about scurvy, in my humble opinion. All right, so this case is the U.S. I've had too much Tang today, everyone. Oh my gosh, versus this lady who was involved in some shady bad business here. All right, so I don't go through the details of this case because it's just so horrible. And also when you've kind of prosecuted cases like this or been a part of cases like this, it's like, I'm not going to go back. I'm not going to go back to that stuff because that's just awful. But when it comes to procedures and any other kind of criminal law situation, I'm all over that, right? So just so that you know. There are a lot of people, creators, though, that do give out some good details and go into the JE files in some depth. One of the ones that I always try to check because I find their information so reliable is Under the Desk News, right? Like they're on the YouTubes and they're on over here on the TikToks, and I am always impressed by the work that they do to put that information in front of us that's truthful and reliable. So that would be my recommendation here. So let's go ahead and dive in here, everyone. Again, this letter was done just yesterday. Here, it's only a couple of pages, then we can kind of go into her docket and see if there's anything weird in there. Because there will be, yes, Under the Desk News, yes. Right. And you know, nobody is ever perfect because we just aren't. So, you know, there have been times when they have reported on something and it was like, wait, that's not quite right. And then in an hour they came back and they say, well, wait, that's not quite right. And I appreciate that so much more than the people saying, you know, I'm perfect in every way. Like, I want someone who has made a mistake, sees the mistake, fixes the mistake, and then keeps going forward. To me, that just seems more trustworthy. So I appreciate her so much. I appreciate them so much over there that gets that show up and running. So exactly, K-Chaos always will come back. Exactly. Yeah, exactly, Jean Marie. Me too. I agree completely. All right, let's go ahead and dive in here. So I will be kind of coding my language if there's any words in here that I think are going to get me dinged. I think we're actually pretty good to go with how they set this out. But we have the Honorable Paul A. Engelmayer here, which is a district judge in the Southern District of New York. Now, again, just as a friendly reminder, everybody, that if you've got U.S. as one of the parties, that means we're in federal court. Some people can get really tangled up here, where they're like, I don't even know if it's a state or a federal case. So when you're looking at it, if the United States is a party, it's federal. If the Commonwealth of, I don't know, Massachusetts, that's a state case. Or New York versus someone, that's a state case. That's just a really easy way to keep it straight as you go through it, right? Because we've got different ways of going through here. Oh, excellent, Colin Food. Yeah. Sorry to say your name right. Yeah, complaining, exactly. That's funny. Yep, let's get into it. So it's from the Department of Justice, which, you know, is compromised, so whatever. Dear Judge Engelmayer, the government respectfully submits this letter as an update to the court's November 25th, 2025 order. So they're citing the docket here. Now, I'm not going to look at that at the moment, but and the government's letter of December 19th of 2025 describing the procedures the government initially implemented to comply with the court's order requiring the U.S. Attorney for the Southern District of New York to certify that the SDNY had conducted a pre-publication victim privacy-related review and redaction of certain of the materials required to be published pursuant to the directives of HR 4405. So this is the name of the law, everybody. I mean, goodness gracious, that it is literally has his name in the title of the law, and it says Transparency Act. So this was a really big to-do. Literally wrote a law telling the DOJ to give this information. I mean, that's huge, right? Usually you're like, okay, DOJ, do your job, do what you need to do. Congress wrote a statute and gave it to the DOJ and said, now it's unlawful for you to keep this stuff a secret here. That's just how much work it took with this Congress. All right, here we go. So that's HR 4405. The E-Files Transparency Act, also known as the Act. While not all of the materials under review are covered by the court's prior orders, the government writes to advise the court as to how it intends to address its obligations under the court's prior orders in the context of how it is handling the review and publication process more generally. So this is okay overall. Sometimes when Bondi's minions work, or even Blanche's, they'll come in incredibly aggressive. I'm guessing like their underlings wrote it and then they come back in and like sprinkle in these really rude comments. But this one's okay so far. So one paragraph at least one bipartisan. Well, hello, Hitch. Hello. It's tough. It's a tough situation, but I have no sympathy. I have no sympathy for you. All right. Specifically, the government writes to update the court on the procedures it intends to follow to comply with the Act, the court's order and related obligations and policy considerations as it works to complete the review and release of files under the Act. To date, the process described in the government's December 19th letter has been used for the subset of materials released that fall within the scope of the court's order. Next, do you know if there has been a filing on the reasoning of the over redaction? I have checked. I've not seen any filing along those lines. I'm not saying we won't, but I've not seen it yet. And also, any of those kinds of issues that do come up, and it might even be in this letter, but it will be filed somehow to make a note of it. But the prosecutors in this case have not. Hold on. We got to flip it. Too. The prosecutors are representing basically Maxwell now. So anyway, the other side is going to need to file something for sure. Since our last letter, the department has continued its efforts to identify, process, and review materials from various components of the department, and two, the Southern District of New York and the department have worked together, including with input from various counsel for victims. Remember, this is the place where they had to fire everybody because they were saying they would not bring a case without sufficient evidence in for a grand jury assessment. So we got to keep that in mind here. To refine our review and redaction procedures. The goal of all of these efforts is to facilitate the release of materials under the Act promptly and to continue to protect victim privacy to the maximum extent practicable as contemplated by the Act and consistent with the department policy and the court's order. Oh, all right, whatever. Overview of the work in progress. So this isn't really that unusual when you have something of this size that you're putting together for discovery. Like, this isn't the first rodeo we've had in the courts when we've had this many documents. Like, they're going to come in here and be like, oh my gosh, there's so much work, we don't know what to do, which is exactly what they did in Florida with the espionage case, and then later in DC. They're like, there's no way you can do a trial anytime in my lifetime because I still want to read all the documents. And we all know that's a bunch of bologna sandwiches. They set a deadline, you got to meet that line, and then if not, come back and ask for more. So this is very typical, especially of this administration, but in a case that's got this much discovery in it, it can sometimes tend to be pushing it down the road. A bunch of whiners. All right. Here's an overview of the work in progress and documents remaining to be reviewed. And again, this is not that unusual. There are several of the other cases filed against the administration now with the new filings, and many of them have letters updating the judges regularly. To date, the department has now posted to the DOJ e-library webpage approximately 12,285 documents. To that I say, so, comprising approximately 125,575 pages. Again, to that I would say, and, in response to the act. And there are more than 2 million documents potentially responsive to the act that are in various phases of review, which that happens, like, is this your first time with this? And again, the 2 million documents for me, everyone, I find it fascinating because, again, it's the same thing he used in the espionage case in Florida. Like, oh, there's too many, and complaining about the skiff and complaining about protocols and not being able to take his phone in and blah, 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 blah. We were looking at this as well. And he's like, I can't do it. I got to blah, blah, blah. And then, of course, later on in DC. So, this is an old trick, but it is used continuously. 5 million, right. Right, exactly. Well, it worked once. Yeah, and they'll keep coming back and trying it as many times as, they think it will work for them. But if you're, I guess in a general criminal case, you're not necessarily, unless it's white collar, going to see this number of documents, unless, again, it's a white collar crime. But, if someone's robbing a bank or something, like we know Wisco does. But you're not going to have this many documents. But if you get into a complex civil litigation case, like the New York versus Orange, when it came to Judge Engeron and all of the false stuff, they could easily have tipped 1 million documents without a doubt, and all of those were available online. So it was a lot because it was a documents case. The key steps in this process: number 1, identifying documents potentially covered by the act, which, as this court is aware, is voluminous, a set of materials given the broad provisions of the act. So they're not happy with the act. They are unhappy with how the act was done. Too bad. That's just how the cookie crumbles sometimes. Here. All right. So that's number 1. Number 2, so they're saying because it was too broad, the law was too broad, whatever. Number 2, uploading those documents to a data review platform. This is some BS again, right? Because they're saying like, oh, well, we got to upload all the stuff. It's just really overwhelming. Number 3, manually reviewing the documents for victim identifying information required to be redacted under the Privacy Act and privileged information. And I pause at this moment and I say, everyone, in my opinion, that the amount of trauma and horror that these victims went through, they'll have the rest of their lives. So take the extra frickin' time to redact their names, right? Like, that's the least you can do to the people who were harmed, in my opinion. Number 4, making appropriate redactions. Well, and I mean appropriate by actually redacting it, I think could be a good question in there. Number 5, prior to posting the documents to the e-library webpage, engage in global quality control checks. Maybe you wouldn't have to do that if you redacted it properly last time. I don't know. Number 6, here's my McSmarty pants going. Number 6, engaging in the Southern District of New York specific quality control checks for victim information consistent with the court's order. The least you can do for the people harmed in this case. Number 7, posting responsive materials. And 8, responding to requests from victims and other members of the public, including requests to remove or further redact posted materials that inadvertently were published publicly. This should not be occurring. This, in a normal case, this would not be occurring. You can't come in and say, well, if I make any kind of clerical errors, whoops. Are you kidding me? We're talking about victims that have been through some horrors. And you're going to say, well, whoops, sorry, we meant to redact, but we forgot. Like, that's not appropriate at all. That doesn't seem okay in my opinion. All right, here we go. Next. There is, exactly. This work has required and will continue to require substantial department resources. I'm wondering if this is actually cut and paste from the Florida case. That'll be interesting. We noted in our prior letter the hundreds of attorneys dedicated to the review at the time of that letter. Currently and anticipated for the next few weeks ahead, in the range of over 400 lawyers across the department will dedicate all or a substantial portion of their workday to the department's efforts to comply with the act. Like, all right, great, good for you. And what about those pro bono attorneys that are like crappy? Because in the legal community, we're like, which ones bowed down? Who did that? Because the respect's gone for pretty much ever. So you could do that with your pro bono people, right? These efforts include over 125 lawyers in the Southern District of New York, as well as a dozen of lawyers from each of the United States Attorney's offices in the Southern District of Florida, the Criminal Division of the Department, and the National Security Division of the Department. In addition, more than 100 specially trained document analysis. What's that? Like, what does that mean? I'm just wondering. Is it like that really creepy guy? Gosh, what's his name again? There's a bald guy and he comes out and he's like, just so stinking creepy. Who's his name? Do we know? What's his name? What's that half bald guy's name? See if we can remember. Is it Sean? Yeah, Steve Miller. Thank you so much. So we've got 100 specially trained document analysis analysts. So what they meant to say was, and 100 people sitting around having a sandwich where the weird fella and his weird fella friends are saying, just say F off to the courts. Like, just wanted to see what their program was here. All right, so they're trained document analysts with experience, handling sensitive victim materials like they did at Doge, right? Oh, I'm so sassy tonight. All right, I got to keep moving through here. The sass is just coming out. All right. Professional. Here we go. Victim materials are assisted from the Federal Bureau of Investigation. Many of the attorneys dedicated to this review from the department have experience in victim privacy-related matters, which is necessary given the nature of the materials and of the types of documents that require careful redaction. Careful redaction here, people. Oh my gosh, we're almost at 100,000. Aren't we? Am I saying that number okay? Hold on. Let me jump up and see. I'm so excited to go and talk about this case once we hit it. Yay! I'm excited. All right, here we go. While the commitment of department personnel to this effort has been substantial, like they don't have any lawyers left really, but all right, in breadth and impressive in efforts, a substantial work remains to be done. As noted above, more than 2 million documents identified as potentially responsive to the act remains in various phases of review and redaction. So, like, that's just how the process works. Like, you don't like the process? Well, So footnote number 2, we had a footnote up here earlier and I passed by. Oh, here it is. So we have the first one here. So this is footnote number 1 and then the second one. So number 1, the term document refers to materials of various types and sizes, including without limitation, internal emails, internal memoranda, FBI interview notes, draft charging documents, Bureau of Prisons material, third-party subpoena returns, court filings, external communications, and various forms of media. Some documents have multiple pages. Oh no, multiple pages. As a result, document counts and page counts are different, and the time required to review documents can vary substantially. So this is a whiner moment where you say, wow, you clearly don't spend much time in courts or going into litigation with major discovery. So, all right, like you have all these people working on it and you're still saying, well, we can't do it. Like, all right. Again, that is my question that I have is like, if it's so hard and you don't want to do it, why'd you do it? Right? All right, number 2 here on December 24th of 2025, the department disclosed that it had identified approximately more than 1 million potentially responsive documents from FBI files that had not yet been incorporated in its review. Based on broad initial reviews of these documents, the department expects that a meaningful portion of the documents are copies of or largely duplicative of documents that had already been collected by the department for review, but nonetheless still need to undergo a process of processing and deduplication. That's my favorite word. Favorite word so far, everybody. Undergo a process of processing and deduplication. That's where I feel like I've heard AI is saying, hi. Is this just a super fancy way of begging the teacher for more time? Well, yes. And it also, though, gives us some insight into how they're going to try to go forward, arguing what it is they want and what they don't want. It was written by AI without telling me exactly right. All right, so page 3. It's not very long. We've got this page, and it's done. So it's really only 4 pages here. But I think it's interesting to know, again, this is 5 years after this woman was convicted. 5 years, all right? So the department's identification and collection efforts span documents that remain to be reviewed very widely. As a result, and in light of its experience to date, in order to facilitate the prompt release of materials under the Act while continuing to protect victim privacy to the maximum extent practicable, it is appropriate for the department to modify its procedures for the review based on various factors, including without limitation, document type, and likelihood that the document contains victim identifying information or privileged information. And this could be attorney-client privilege, everyone here. So we don't forget that's also one of the defenses that he put in every single criminal case. So the espionage case, he said, attorney-client privilege. The New York fraud case, it was all privileged. The DC case filed from Georgia, it was all privileged. So this is like one of his very favorite things to do, is to use attorney-client privilege as a affirmative defense to get in there. So whatever. Oh, we're at 100,000. Are we there? We're almost there. Almost there. Here, let me finish my paragraph here. Oh, I'm so excited. All right. Here we go. In likelihood, the document contains victims' identifying information or privileged information. A more detailed discussion on these document type specific procedures appears below. All right, everybody. Oh, we made it. Thank you. All right. So this is the moment in our program where we do a real quick overview of a landmark U.S. Supreme Court case. So, oh my gosh, this is so fun for me. I don't know about any of you, but it's super fun for me. So yesterday, we did the Katz case, right? So that was a case out of the 1960s, and it set out really the first verbiage regarding expectation of privacy, right? So privacy is not in the Constitution, it's in the penumbra or in the water blots of the Constitution. So it's kind of like implicated under the Fourth Amendment to be free from unreasonable searches and seizures that like hints at privacy, but certainly doesn't set it out in a way that we understand. So it's kind of like in the water blots, right? So with the cat's case, we had a phone booth. He was like making some phone calls, then they like wiretapped it, and the Supreme Court said you need to get a warrant because you can't just wiretap somebody's phone booth when they think and have a reasonable expectation of privacy. This is a different case. This is a little bit older case, but oh my gosh, this is one, in my opinion, of the best cases, which is what I'm sharing with all of you. So this was in 1879 is when this was argued. So we have Strouder versus West Virginia. All right, so here we go. We have the petitioner, Mr. Strouder, and the respondents, Virginia. And it was the Waite Court. That just tells you who was in charge of the court at that time. Like we're in the Roberts Court era. So down here we have a full citation, which I pulled so I could get a little bit more of the facts out for this case for you. Again, argued in 1879, decided in 1818. Here's the facts of the case. Very simple. A West Virginia law declared that only YTs may serve on juries. So the question is, and again, keeping your eye on the time, so 1864 is when the Civil War was over, and then we have the 13th, 14th, and 15th Amendments passed, all right? So this is not too long after the war, but definitely struggling with how these amendments apply to everybody. So it's a problem. Here's a question then, of course. Does the state law barring people of color from jury service violate the Equal Protection Clause of the 14th Amendment? Well, let's see here. Is that a gemstone? No, this is a cognac quartz. I think it is just a really pretty quartz color with the cognac. If it was like a regular jewel, no. Sorry, but nope, I wouldn't have it. I would have sold it. Real quick then. Oh, I know, Selson, I know, they're still arguing about it, and we're still doing it. Oh, citrine. Yeah, that sounds like it could be right. I should know, but I don't, I guess. All right, here we go. Real quick, let me read to you just the first couple of paragraphs. I can't read you the whole case here, but I want you to get a good idea. And again, we're doing these bonus cases just because these are really important cases, and you probably haven't heard of them, but yet they're still just as important as Marbury versus Madison or Arizona versus Miranda. So here's our syllabus, just a quick blurb here. The 14th Amendment of the Constitution of the United States, considered and held to be one of a series of constitutional provisions having a common purpose, namely to secure to a recently emancipated race, which had been held in slavery through many generations, all the civil rights that the superior race enjoy, and to give to it the protection of the general government in the enjoyment of such rights whenever they should be denied by the states, whether the amendment had other, and if so what, purposes not decided. The amendment not only gave citizenship and the privileges of citizenships to persons of color, but denied to any state the power to withhold from them the equal protection of the laws. This is that piece that a lot of people keep arguing about. Do immigrants have this as well? What if their documentation is not where it should be? Do they still have equal protection of the law? They do. So, equal protection of the law is an invested Congress with power by appropriate legislation to enforce its provisions. The amendment, again, we're talking about the Equal Protection Clause. The amendment, although prohibitory in term, confers by necessary implication a positive immunity or right most valuable to persons of the colored race, the right to exemption from unfriendly legislation against them, distinctively as people of color exemption from discrimination imposed by public authority, which imply legal inferiority in civil society, lessen the security of their rights, and are steps towards reducing them to the condition of a subject race. And that was one of the things that I think really hit a lot of our Supreme Court justices. Is there like, this is smacking of what happened in England a bit, and so that was like unacceptable. Next, the Statute of West Virginia, which in effect singles out and denies to people of color who are citizens the right and privilege of participating in the administration of the law as jurors because of their color, though qualified in all other respects, is practically a brand upon them and a discrimination against them, which is forbidden by the amendment. It denies to such citizens the equal protection of the laws, since the constitution of juries is a very essential part of that protection, which the trial by jury is intended to secure. The very idea of a jury is that it is a body of men composed of the peers or equals of the person whose rights it is selected or summoned to determine. That is, of persons having the same legal status in society as that which he holds. So and they're talking about the menfolk, all right, the ability to sit on a trial, on a jury for women came in the 1900s, actually. And I want to say it was like 1984, somewhere around in that range. So we're talking about men here, just the men, all right? So, and they're saying, you know what? We all have equal legal status, and we need to respect that. Whereas here, the state statute secures to every white man the right of trial by jury selected from and without discrimination against his race, and at the same time permits or requires such discrimination against the men of color because of their race. The latter is not equally protected by law with the former. Number 6, Section 41 of the revised statutes, which declares that, so here's the statute that's coming into question here. I've only got 2 paragraphs left here for our fascinating case here. Quote, when any civil suit or criminal prosecution is commenced in any state court for any cause whatsoever against any person who is denied or cannot enforce in the judicial tribunals of the state or in the part of the state where such suit or prosecution is pending, any right secured to him by any law providing for the equal civil rights of citizens of the United States. Such suit or prosecution may, upon the petition of such defendant, filed in said state court at any time before the trial or final hearing of the cause, stating the facts and verified by oath, be removed for trial into the next circuit court to be held in the district where it is pending. Right, so they're like, dude, follow the rules or you're going to need to go somewhere else. So considered and held not to be in conflict with the Constitution. So they're like, our law is fine in West Virginia. And then the courts are saying, the facts are stated in the opinion of the court. So you can keep going further on this. I won't tonight because this is just kind of our bonus case. So I want to make sure we have plenty of time for the rest of our show. But this is the right here, the name of the case here. And then this is, it's a Supreme Court case because of how it's cited. And again, 1879, 1864 was the end of the Civil War here. So those are also very important. But at the very end, the conclusion, I think that's, done quite well. We'll go back to the Oye document here. And it says, the question was, let's just make sure we get the question right here, everybody. Grammar or grammar? Oh my gosh, good question. To say, guys, really, KL? Oh my goodness. All right, here's our question. Does the state law barring people of color from jury service violate the Equal Protection Clause of the 14th Amendment? And yes, it does. strong writing for the majority, declared that to deny citizen participation in the administration of justice solely on racial grounds is practically a brand upon them affixed by law, an assertion of their inferiority and a stimulant to that race prejudice, which is an impediment to securing to individuals of the race that equal justice, which the law aims to secure to all others. And so that's, I think, an excellent quote. So there are just a ton of cases regarding, I can't emphasize this enough, everybody. With U.S. history, you're not going to be able to go through any era in U.S. history, any era, without seeing the fight for equal rights. Without seeing people that are pro what had happened with slavery and anti. It's in every single piece of our history. And it's, if you got rid of it, then our history would just crumble because it's inaccurate. So one of the things that I'm trying to start doing is incorporating more of this incredibly important history in that a lot of people don't know. I mean, we're talking 1879 here, and this was a strongly worded decision by a Supreme Court justices who said, this is awful. They should be on a jury. They are entitled to equal protection. They're citizens, and by refusing to put them on a jury, we are, we are not following within the constitutional piece that's necessary for fair trial. So that's that, and that's my special case for tonight, one of my favorites. I've got several others out there, but this is one of my favorites. So we've done the Katz case now, we've done the Schroeder case, and again, I believe women were finally put into the same category, but I think it was in the 1980s, actually. So you can look that up. I may be wrong on that. So there you go. Special case for today. Thanks for the 128,000 likes. My goodness. Thanks, everybody. Oh, thank you so much. Yes, quite right. Quite right. YT women. So that's where things get really unusual because the way the case set out was not specifying YT women, because they were using the Schroeder case to say that if you're a woman, basically if you're a person of color, you still need those same rights. But I will tell you, when it comes to setting out the power structure of the United States, you will find that women of color are at the very bottom, and they have to push the hardest of the major groups. In order to just get their fingertips on some civil rights that they're entitled to. So there you go, everybody. A little history. All persons born exactly right. And that's another thing, too, when we get into this birthright citizenship road that we're going down. It's like there's a lot of history to this. A lot of history. Yes, I do have a tube of you. I'm a little bit behind in my posting, but I've got 2 posts ready to go up tomorrow on the indictment of the Venezuelan fella, and then kind of trying to get my other ones in there. So as best as I can. Yep, same name. All right, here we go. We're going to hop back in. Again, there's only 2 pages here left of this one. Yeah, we have more degrees than 8. Well, that's the thing. I mean, it has absolutely nothing to do with intelligence. And if you pull intelligence out of the facts or out of the factors, right, then it's not merit-based anymore. Surprise, surprise, Mr. Orange. All right, here we go. Back in it. Whew. All right, victim engagement and modifications to the department's victim privacy efforts. So let's see what the DOJ has done. Since the passage of the act, again, it's that Privacy Act saying the JE files need to come out, right? The department has received dozens of inquiries from victims, victim representatives, and other members of the public requesting that materials be redacted to protect victim privacy. To date, the department has compiled a list of hundreds of individuals for redaction. hundreds of individuals as we remember what this case is really about, right? So when you're thinking, like, this is not a normal criminal case. This is absolutely not normal. So this list includes names of victims and other individuals, such as immediate family members, that should be redacted to provide as much protection of victim privacy as is practicable. Right. I don't believe anything the regime or their lawyers. I don't blame you one bit. I think we're at a point now where blind faith no longer exists. I think everything has to be checked. Everything needs to be checked to see if it's actually the truth or not. The truth for us, right? Ooh. Right. Yeah, I don't blame any of you. Exactly. Right. All right. So, I've got a stop censorship karma situation going on. What's going on, karma? What's the diddlio here with that? Thousands. Yeah, I know. Right. Well, the good faith piece is definitely shaky at best. Right. South Carolina. Well, right. I know. You've never seen anything like this stuff before. Yeah. Well, I mean, this is it. This is the primary source documents here. We're getting it. We're still looking for the correct path. True. Fair enough. But I wanted to say censorship on a private app is just kind of like not a thing. So I'm sure the mods have it taken care of. So let me dive back in because, this is how we know that the information is good or not. There isn't one perfect one. There's no perfect anything that's perfect, right? Anything. All right, here we go. Based on these interactions and its experience with the Act to date more generally, the department has modified its efforts to protect victim privacy. Recent modifications include, without limitation, 1, modifying the process for responding to requests to remove victim identifying information. Here's number 4, so let's hit that footnote before we forget. Here, the number 4 here, any victim seeking to have information redacted that has been posted to the website is able to submit that request to this address here. This email inbox is monitored by a team of department attorneys who review all such requests. Separately, the Southern District of New York continues to confer with certain counsel for victims and to provide updates as circumstances allow. So that's kind of our footnote that they're adding on here. So number 2, running additional electronic quality control searches where technology allows to better ensure the protection of the victim, identifying information. 3, refining proactively engaging with various offices within the department to ensure that all potentially responsive materials have been identified. I may have skipped a couple of words here, everybody. It's okay. You get what I'm saying. And number 5, improving the processes for identifying and handling duplicative materials, including duplicative materials located in separate records that require consistent redaction to protect victim privacy. All right, so let me do one more quick footnote here for number 3, and it states, as noted in our prior letters to the court, again, this is a letter to the judge, to the court here. As noted in our prior letters to the court, victims include individuals identified as victims or potential victims through the department's prior prosecutions of the E-Guy and Maxie, as well as all individuals who have directly or through counsel been identified, including self-identified to the department as potential victims of state or federal offenses or other claims of sexual exploitation or misconduct by Mr. E or Ms. Maxie. The department also has endeavored to redact victim identifying information beyond the names to the extent practicable. Does anyone see, just for a quick question, moderators, you're working so hard tonight. I appreciate you, each and every one of you. I appreciate you. But let me ask you this again. This is our last page here, but how do we feel like? Hello, Willie B. Welcome in. Hello, Kate. Good to see you. Yeah, the moderators. Woo! What would I do? What would I do without you? I wouldn't be able to go forward. One thing, though, before I forget, everyone, if they're saying we want anyone coming in who wants to tell us about being a victim, survivor of this, that's fine. We've got this policy. Let me ask, who is going to be able to walk into the Department of Justice with the orange perp in the White House and feel comfortable about talking about being assaulted? Can I just ask that question? Who's going to do that? Already people are too ashamed, worried, fearful to share that information in the most private of situations, like in a hospital room, right? They're like, I don't want to say anything. So let's go to the Federal Department of Justice that are essentially the Orange's own team of attorneys and sit down and tell them about something awful. So the practical piece of this, or what happens here, the consequence for putting an SA in office, is that we're gonna have a lot of people hiding and hurting, and that's just too bad. Right, using it against them. Exactly, Kaya. Exactly, and it's heartbreaking, unless they're already named True. Have already come forward against, yes, and right, Casey. Good point. And it's a struggle. It's a struggle. I think we have definitely opened the eyes of a lot of the men folk to how huge a problem is, and the women folk who don't pay attention. I think we've definitely opened their eyes to many of them that are not on the other side, right? So I can't say the same thing for the other side because of what they have been saying, but I think some eyes have been opened. We'll see. Oh, I'm doing all right, Ken. Like Ken here. Very reliable, amazing person. So, yeah, see, can't just clump everybody all together. Although, don't think I don't know that you have muted me before. Ken, I know you have. All right, moving on. Last page, everybody. The department remains committed to providing as much protection to the privacy interests of victims and their relatives as is practicable. Prior releases have included tens of thousands of manual redactions of victim identifying information. This is where I pause and I say, what, this is your first time doing discovery? What's the issue here, right? Even with these efforts and related quality control checks, unfortunately, information that victims believe should have been redacted has been posted. The department has applied additional redactions at the request of victims, counsel, and others. Here, I'm trying to make sure I don't miss my puzzle, and continues to engage with victim counsel about these matters in an effort to best comply with the act and also afford maximum privacy protections to victims. In particular, an issue that the department's continuing to consider and confer with victim counsel about how to handle documents that have been filed in public court proceedings other than the case before this court that contain information about the victims that victims now seek to have redacted. I see it up here. Unfortunately, it probably is their first time doing discovery with the lot they continue to pick. I would agree. I think because so many, oh my gosh, what is it? 70% of the attorneys have left the Department of Justice in one way or another because of ethical concerns. So they're working on a skeleton crew already. And a lot of times they're going to get a bunch of interns in that they don't have to pay from law schools around in the area. And, that they probably have never seen anything like this either. And so they're digging through and trying to do something that's way outside of the scope of what they understand and know. No offense to them. They're doing their best. But that's what happens when you go in the door and you fire everybody the first day. Right? So you're taking a baseball bat in when you need a scalpel, and it shows, and it certainly shows quite a bit. It really is dangerous. It really, really is. Inability to redact appropriately weaponized and competent to punish this. Could be, Casey, but honestly, I don't know that they're trying to punish survivors as much as they're trying to punish any attorney helping them or anyone on the other side. Like, I'm not sure they're going specific into the victims for all of them. But then again, I say that, but then again, I take a look at what happened with Stormy Daniels, quite frankly, and I choose her because we have a criminal case that was wrapped up in. And to think of, like, where is she having to hide right now? Is she safe? Is she able to, go to the grocery store and get some milk? Those are the kinds of things I think about when I see that the orange is in the White House, right? So whether or not it was just to go after the victims, again, could be more likely, again, I believe, after the attorneys, right? Here, like Jack Smith and Letitia James. I mean, there's a lot, but it absolutely could. It could include that. Really? Oh, wait. Okay, James, in crisis intervention, this administration has dramatically reduced reporting. Oh my gosh, I'm not surprised. It's not safe. It wasn't safe in the beginning, when it first was able to be recorded and it became like okay to tell people your story. It wasn't good then, but it certainly isn't where it should be now. And I think that the administration set us back as women quite a ways. I don't mean to not include everybody, but you know what I'm saying when I say women, which I know is a gendered word, so maybe I should say female. I'm working on it, everybody. I'm working on my rainbow language. Got to get it right. Jack Smith's testimony recently at all. Yeah, so Ken, the last couple nights I've been going through it. I'm actually reading through his transcript, so word by word, and we're kind of going through and being like, that's not okay. Highlight it, like, that's also not okay. Women have to band together no matter what. Absolutely. I mean, there's definitely some we're all different people. There's some ladies out there that are just very, very poisonous, so we don't speak of those, but the others, yeah. I was with Grandma this week. Oh, bless. Oh my gosh. Oh, bless. Well, I know when you have a relative that is needing a lot of extra caregiving, it's very hard on the caregivers. But thank you for doing that. All right, here we go. Next up, 98 in 3 months. Dang. Oh my gosh. My goodness gracious. That's amazing. All right, here we go, everyone. I'm in the last page. I know a lot of people are like, get to it. Sorry about that. Update modifications to the department's review and redaction procedures in an effort to publish responsive, non-duplicative documents as promptly as practicable under the Act, while maintaining its commitment to victim privacy and complying with the court's orders. The department intends to incorporate the following procedures as it completes its review of potentially responsive materials. Again, this was filed as a letter to the judge in the Maxwell case by the Department of Justice. All right, so this was just yesterday. All right, here's the first one. Undertaking manual electronic efforts to duplicate materials. That's bothering me. That word is bothering me. I'm like, don't use that word, man. That's crazy. Efforts to deduplicate materials collected from various components of the department. I don't know that components is the proper word here either. I've turned into an English teacher. Oh, my goodness gracious. Yes, indeed. Right, exactly, everybody. Next, prioritizing the review of documents that are expected to be responsive and non-duplicative for review and publication, classifying documents in broad types based off of department's assessment of key characteristics, including whether the documents would be expected to include sensitive victim identifying information. This might actually be a bit difficult for people who are just coming in with no history whatsoever on SA cases. That's going to be a bit of a learning curve there to figure out what is okay and what's not okay. Next, for the prioritized documents that are expected to include sensitive victim identifying information, assigning department lawyers, including in particular, comma, lawyers with experience in handling victim information and sensitive matters. Those lawyers are gone. Those lawyers are gone. And the fact that Bondi thinks like, oh yeah, we'll get the experts in here. Guess what? You're not the expert, Bondi. All of the experts have been fired. Anyone that could fight back or stand their ground against Bondi is gone. So, like, let's just be real about it. Let's just be real. Attempt to remove duplication. Posted a numeral amount of duplicates. Oh, exactly, KK. So for anyone, and just a quick question here, because we are coming down to the end of the document, but has anyone that has gone through the batch that was released last year compared it to the batch that was just released, like the similarities in those documents? That's one of the things that I'm worrying about when I'm reading through. I'm like, wait a minute, has this already been released? But yet they're using it as a way, quantity, as a way to be like, oh yeah, here's all the stuff, but it's just flooding stuff that we've already had. Also tried to pass them off as new multiple times. Yeah. Dedupe is used in IT backup software to eliminate backup copies of the same file. Oh my gosh. Major learning moment for me. All right. So let me just write the word down here. Dedupe. That may be my next favorite word ever. Dedupe. All right. We're deduping. Oh my gosh. Yeah, I'm sure. No, nobody's on it. World's crazy. Yes, Dolphin. I got you. It's used in business a lot. Okay. A Steve Bannon strategy. Whatever. If it works, I don't care whose strategy it is, as long as it's not illegal. Right? Like, you can build a hole. You can dig a hole in your backyard. That's perfectly legal. What you do with that hole, keep it to yourself. All right, here we go. Back to it. Professional. Consistent with the course order, this review process includes Southern District of New York lawyers, and in particular, New York attorneys are assigned to the materials most likely to contain sensitive victim identifying information, as identified through searches and segregating categories of sensitive materials, such as victim 3,500. Why would New York attorneys be the ones? They're saying it like that's a plus, but I mean, the harm was done all over. So it wasn't just in New York where the harm occurred. So I don't know. All right, New York lawyers are also involved in quality control reviews for victim-related redactions of materials that, while not expected to contain victim names, are produced under the Maxwell protective orders or are believed to be duplicative of materials produced under such orders. The department believes that these procedures best serve the interests of the victims, the purposes of the act, and the court's orders, and the public interest generally. As always, the government's available to respond to any questions from the court. That's not true. And then it's signed here, respectfully, Bondi, Blanche, and then, this fella. And then it's signed here, respectfully, Bondi, Blanche, and then, this fella. We don't know who he is, but probably has a loyalty contract signed. John Roberts, a letter saying, I don't know about that. I don't know. Recheck. I know. Oh, they really are. They're fibbers. And again, I can't emphasize this enough, everyone. When I am able to listen in on live court recordings or hear or read through transcripts from these attorneys, right? It is just blows me out of the water when the judges are like, I don't believe you. Like they don't even, beat around the bush. They're just like, nope, I don't believe you. So we got to do something that makes me comfortable enough to know that you won't try to get around it. And that's unusual. You don't see that from judges typically, even in the worst of the worst jurisdictions, which I don't even know what that would be, but the worst of the worst, those judges are still like, come on in, we got to do some work. But I've never seen this before. Just so many of these DOJ attorneys just getting dressed down, and rightfully so. So, in my humble opinion, weren't they redacting his name long before? Yes, exactly. They pulled in 1,000. I didn't know the number, but it was huge. They're awful people, only looking out for themselves. Well, the thing is, I don't like to, say an entire group of people are awful. So I'll put it this way. In my own personal anecdotal memory, everybody that's been in that group that I have personally been talking to or doing something, they're awful. They're just awful in my own personal experience. I'm in a red state, so I think that changes things a little bit too. But yeah, we're definitely, again, when we think about what's going on in the world, what has happened in our history as well, when we've got the North versus the South, right? And those are families even that lost connection because of that. And I think this is one of those key pieces, key morality questions where it's just like, this is the line. Like, we drew the line that they wouldn't draw. And that led to them being kept out of that world. So that's my personal opinion, my personal take on that. I know 2 women. Well, and so be it. I don't think at any time, if anyone comes up and says, I voted this way and I regret it. And I think in my humble opinion, the worst thing you can say to that person is, well, it's all your fault now, so good work. No, I don't think that's helpful. I don't think that will do anything. What I'm finding myself doing is asking a very simple question. They'll be like, hey, I made a bad choice. I didn't know, whatever. And I just say, have you contacted your congressperson and told them that? Like, just, why don't you give them a call and tell them how and why you changed your mind? And, don't be worried, do it anonymously, whatever. But, go and do something that is proactive that perhaps you haven't done before with this new way of thinking. So that's how I put it, as opposed to, let's go, make you go sleeping with the fishes. Unless I'm in Hulk mode over on Amanda's, then that doesn't matter. Then everybody's going to the fishes. All right, we have to talk about that. The empathy is pretty low. I agree. The empathy is incredibly low at this point, and rightfully so, in my humble opinion. Again, if someone's like, I've changed my mind, I'm not going to come chasing after them. But on the other hand, I think the acknowledgement of the harm that was voted for, I think is important as well. Not the fishes. No more sleeping with the fishes. The Hulk mode. I am like, it's not good, everybody. When I lose my temper, it's not good. It's a bad thing. It's my kids are like, why do you lose your temper all the time? I'm like, well, we're talking to a schmatzi. And they're like, maybe don't talk to schmatzis. Oh my goodness gracious, everybody. All right, last little bit here before I go. Oh my goodness. Yes, I know. I gotta take a little break, I think. Not good, but hilarious. Yes, I'm gonna take a little break, I think. I'm getting a little too intense. It's like before I even turn it on, I'm like ready to start like throat punching people. And I know that that's bad and that's wrong. So I gotta take a little break. All right. Back into it here. All right. So one of the letters I just read, you have to kind of have permission to unseal if you have requested them being sealed and so on. So it was the first week in December, and the court was like, okay, we'll make these open and available to the public. And again, we have a motion to vacate here that was filed by Maxwell. I've not done a lot of research. I'm assuming the motion to vacate is to vacate her sentence, is what I'm assuming she's trying to do here. For the reasons herein, the court grants DOJ's motion to unseal, right? So she's trying, she's asking to, in my opinion, based off of what I'm seeing here, she is asking to vacate her prison sentence. Just take breaks. Right. Well, it takes a lot. It takes a lot to, when you get all upset and stuff, it takes a lot to, and it's not, for me, it's not really about, the schmatzis and the, other groups of bad people. It's not really about them. Like, they can go and do something and I don't really care as long as it, doesn't hurt anybody. What bothers me is how I deal with it, right? So, like, if I can't keep my cool in this kind of a situation, then it shows me that I need to do more work so that it doesn't upset me, so that I don't have to rage out. That's me, and that's because I have a bad temper. Yikes. And that's what anger management told me I should do. But, yeah, so, there's good times. There's some times that could have been better. They anger me to a point that my words, I know, okay, chaos, I know, absolutely. And I always tell my children, like, don't be starting fights. We, in this family, we hurt people with our words. So my kids are out there like, do you even know how to spell existential? And they're like, no. And then my kid will spell it, and I'm like, oh my gosh. I'm so proud. Anywho. Back to it, everybody. Back to it. Here we go. Here we go. We've got December 22nd. This is the docket again, everyone, just to remind you. And it says here, to the defendant, the court has directed the government to complete this process by January 6th, right? So the government, so the DOJ here is the one putting together whether or not her sentence is going to be vacated or she's going to be pardoned. The government that's supposed to be the one prosecuting her, putting her in prison, watching her in prison, that's the DOJ, and that's completely under the orange control. So, yeah. As to the briefing schedule on the motion, by March 31st, so we've got some brief dates. And then April 30th is the response. And then let's see, December, no, that's 26 here. So I think we're just scheduled to, here's February 17th of 2026. Let me just make sure here we've got the right dates. We'll be set to revise the briefing schedule. All right, so we've set out different briefs, briefing times, what's allowed publicly to be disclosed versus what's not allowed to be disclosed. So that's going to be the main order governing like the next 6 months of her life. Pop on and off a few yeah. Well, and that's okay. That's okay. Don't start fights, but you can finish them. Well, I don't know about that. If there's a camera, no. If there's a camera, just like toss a bow like you're playing basketball. That's what I would say. Oh my gosh. I don't know how I got down this road. Now I feel bad. Don't assault people, everyone, all right? Don't assault people. That's not good. And one last thing, too, and I had to share this. John, if you're still here, I was like, I got to show everybody this. See this right here? Right here? That's my cat. My cat literally was eating this paper. Literally eating the paper. I mean, here I am printing this out, and it's like 150 pages. And I come back, and my cat is like, oh, sorry. She didn't even say that. She's such a diva. But had to share. You're wondering, I know, right? Right? I don't know, Navy vet. It was Pearl. Oh my gosh, it was Pearl. Yeah, it was. And I don't know, when I get really upset and frustrated with Pearl, I just, give her the stink eye. That's the extent of it. But anyone else, I think I heard my husband say, like, to Pearl, you don't want her looking at you like that. Just run to my cat. Oh, so funny. Oh my gosh. Yes, yes, and the plastic bags, of course. So, thank you for the chit chatting here with me at the end of our program tonight, everyone, because this is such a heavy case. Miss Maxwell's case is so heavy. And of course, Venezuela, what's happening there is heartbreaking, difficult to watch. Although, again, I believe we will be in a hurry up and wait situation where once this motion to dismiss gets filed and gets argued, that's when things are going to pick up one way or the other. So that's kind of like keep your eyes out for that. When that comes, that's when we're turning a corner from just hanging out and trying to figure it out. So chewing my curtains for some reason. Yeah, I got these curtains that look like they're chewed up at the bottom. So I'm like, it's artistic. We got some 1920s going on here. Schnauzer. Oh my gosh, I bet. If the orange pardons her, is there anything the survivors can do? Well, I would say, depending on your statute of limitations, you could file lawsuits. I would say there's nothing that they can do directly against the government legally. So, I mean, to like sue the government or whatever. There's nothing like that, unfortunately, for because basically you can't sue them for doing their job bad or doing their job wrong. You can't really sue them for that. There has to be something else. There has to be some kind of intent or whatever. It's difficult to get around that. Yes, legally, but yeah. We go back to my suggestion of sending a little jar of pennies. Actually, pennies are in short supply these days, something else. But you put some rocks or some pennies in and you just shake it. Every time they try to talk, it's like, what? What'd you say? I didn't hear you. What? Wait, no, what? Oh, that's one of my favorite things to do. Oh, goodness gracious. Could a state bring charges against her? Possible. It's possible. I don't know what all she was charged with, but I've got no doubt that there were some state laws that were broken. But at this point, also, we got to remember statute of limitations. Right. Yes, indeed. Yes, indeed. We've got to have, hey, I'm telling you, shaking that can is very important. So, but with that, my friends, I do need to go. Oh my gosh, always fun to hang out, and my amazing moderators make it so we can all learn together, which is great. Personal, yeah. I mean, it's not it's not good. It's not good. It's not the end, but it's not good. So take care. Oh my gosh, Dolphin. Oh, that's so sweet. Oh, I appreciate you all so much. Well, take care, everyone. Thank you for all of the likes and all of the support. I'll see you all again very